Yeah, with digital technology, one creative tool that is increasingly used by many musicians and recording engineers is sampling. Is taking existing recordings and copying directly snippets of those recordings and then manipulating them, changing them, and inserting them in new original soundtracks, right? Practice known by most musicians as sampling. Probably needs no description. At least through the sampling really began principally as part of sort of predecessor to hip hop music. It was really a central part of the cultural aesthetic of hip hop music. And through the 1980s, it was a practice that was widely engaged in and generally perceived to be not an infringement of copyright because it involved just the taking of a couple notes from an existing sound recording. But beginning in the late 1980s, a couple courts began to say that sampling is an infringement of copyright. It depends on how much is taken and whether the sampler takes sort of the very key, most sort of heart of the work, or whether it's something which is not the key to the work. And really since then, record labels have begun to insist that those who want to sample have got to clear licenses for sampling. And as a result of that, the practice of sampling, at least for commercial sound recordings, has really declined substantially. Top hip artists today still sample, but have much fewer samples on each track than used to be the case because it's just very expensive to clear the rights in samples. So the law today is basically that sampling might be a fair use, depending on how long it is and what's taken, but is not always going to be a fair use, or sometimes what's called a de minimis copying. If only one or two notes is taken, then it is likely, might not be an infringement of the copyright in the musical composition. There's one recent case in the Sixth Circuit, which held that with respect to the sound recording, so when someone digitally samples an existing sound recording, they are copying both the notes in the musical composition and also in the sound recording, which are two distinct separate works. So at least according to this court, even if you sample one or two notes from a sound recording, there is no de minimis exception. It might be fair use, but it is prima facie infringement of copyright. So there's a different rule. It's more strict for the sound recording than it is for the musical composition. That decision has been widely criticized. I personally think it's very poorly reasoned, but that is sort of a note of caution to those who engage in sampling. So I think today, many musicians who sample either just hope they won't get caught or bury the samples deep within their tracks, so it's difficult to discover what is the source of the sample. And at least for the musical composition, that actually it's in some ways that's a legitimate practice recognized under copyright law, because one of the tests for whether copying is de minimis and therefore is not infringing is whether a typical audience would recognize what the source of the sample is. So if the sample is very short and it's buried within the track and no one will recognize where it comes from, then it's a good argument that it's not infringing. But many musicians think that, well, if you only copy less than 5 notes, it's not a copyright infringement. And that's really an urban legend. It's not true. It depends on what notes you're copying and whether or not they're recognizable and what the court thinks of it. Whether or not it's going to be infringement on one hand or fair use or de minimis on the other. If you don't sample, but rather make a new recording of the notes that you otherwise would have wanted to sample, then you're not copying the sound recording. So there's no need to clear rights from the owner of the copyright in the sound recording, because the owner of the copyright in the sound recording only controls the rights to actually physically duplicate the sounds that were recorded, not to recreate them from studio musicians in the studio. At the same time, though, you probably do have to clear the rights and not enjoy the compulsory license from the owner of the rights in the musical composition, because the compulsory license for cover recordings only applies if you haven't distorted or significantly changed the melody of the original. And in fact, the law isn't clear, but if you're only recreating a a couple notes of the original and then merging it into your own composition, you probably don't fall within, that restriction on the compulsory license. So you probably do have to clear the rights to the musical composition.